How are student-athlete agent agreements changing? If you are curious about how student-athlete agent agreements are evolving, you are in for an interesting discussion. The landscape of college sports is shifting, especially with new regulations and legal changes. Let's break down what is happening. Agent agreements are contracts between student-athletes and agents. These agreements help athletes negotiate deals, including those related to name, image, and likeness rights. This is a major change from previous restrictions imposed by the National Collegiate Athletic Association. One significant change is the introduction of revenue-sharing agreements. Starting on July 1, 2025, many Division I universities will share revenue directly with student-athletes. These agreements can give universities considerable control over the athlete's name, image, and likeness rights. For instance, universities might have the right to change compensation terms or reclaim payments if an athlete transfers or is dismissed. This creates a new type of contract that is different from traditional third-party deals. Another important aspect is the lack of standardization and legal protections. Unlike professional sports contracts, these agreements are not subject to union negotiations. This means student-athletes and their agents must seek legal advice before signing to avoid unfair terms. Starting on June 7, 2025, any name, image, and likeness deal exceeding $600 must be reported to a new clearinghouse called NILGO. This organization will review contracts to ensure fair compensation and prevent exploitative deals. If a deal is rejected, student-athletes can appeal to a neutral arbitrator. There are also new rules that allow student-athletes to terminate or modify agreements that do not comply with regulations without risking their eligibility. If a deal is rejected, athletes can return payments and renegotiate terms, which adds a layer of protection. Schools now have to notify the National Collegiate Athletic Association each academic year if they choose to participate in the new revenue-sharing settlement. They are also responsible for multi-year agreements with athletes, which holds institutions accountable. Additionally, the changes affect roster sizes and scholarship limits. Schools may adjust these factors due to the costs associated with revenue sharing, which can impact agent agreements as well. For student-athletes balancing sports and academics, it is essential to review any agreements carefully, ideally with legal counsel. Understanding the new reporting requirements and arbitration options can help protect eligibility while maximizing opportunities. Being aware of the potential for universities to reclaim payments is also vital when considering long-term commitments. Navigating these agreements can be complex, but staying informed and seeking guidance can help student-athletes manage their sports careers alongside their academic goals.